United States Institute of Peace sounds very nice. The parties and amici, I think the actual argument starts a couple pages in. The ruling under review, of course, is that of the Honorable Judge Beryl Howell, where she granted summary judgment to the Institutes of Peace, saying that Trump lacks the executive authority to fire them. Let's get right to the argument here. The government, meaning Trump, respectfully moves to suspend the district court's order reinstating principal officers of the United States whom the president has lawfully removed from office. So again, Judge Howell is once more telling President Trump that he's compelled to delegate his executive authority against his will to people working in opposition to his administration's policies. So Howell had ordered not only that the firing was unlawful, but all these people have to be put back in office, all their property returned, all their data returned, their loaded guns, everything has to be wound back to the moment before Trump took any action against the U.S. Institute of Peace. Now the White House argues that unprecedented order by Howell works a grave harm to the separation of powers, that there are three independent, co-equal branches of government, and any one may not infringe on the powers of the other, except as explicitly provided in the Constitution, and this is not provided for in the Constitution. Just as the Supreme Court granted a stay pending appeal in Trump v. Wilcox, that's the case we've been talking about, where Howell was reversed 6-3 by the Supreme Court last week. In fact, the day before this appeal was filed, is warranted here. The Constitution vests the entirety of the executive power in the president, all of it, which encompasses the authority to remove those who aid the president in carrying out his duties. The lawsuit challenges the president's exercise of his constitutional authority to remove appointed members of the Institute of Peace Board of Directors and subsequent actions by the new Institute of Peace leadership that was put in by Trump. On May 19th, Judge Howell granted summary judgment to the plaintiffs, holding that the plaintiff board members who've been filing that their removal was ultra vires, outside the law, and thus the subsequent actions of the board were null and void, and ordering that the removed board members and president continue to serve in those positions, contrary to the will of the Article 2 executive branch president. That extraordinary relief is significant and unjustifiable intrusion on the president's constitutional powers. The government is likely to prevail in challenging Judge Howell's holding that the president lacks authority to remove board members except under conditions set by Congress. Those statutory restrictions are unconstitutional, as was just found by the Supreme Court in reversing Judge Howell on the Wilcox firing. The president, as a general matter, has authority to remove those who assist him in carrying out his duties. That's the U.S. Supreme Court, 2010. The Supreme Court in Humphrey's Executor, we've talked about that case a lot, from 1935. That's where an executive branch officer was fired by then President FDR, sued for back wages, died. His estate continued the lawsuit, and he was awarded back wages by the Supreme Court. But what did not happen in Humphrey's was the president, FDR, was not forced to delegate his executive authority against his will. All that happened was that back pay, money compensation, was ordered. The Supreme Court in Humphrey's Executor recognized a limited exception to the at-will removal for a multi-member body of experts balanced along partisan lines that performed legislative and judicial functions and was said not to exercise any executive power. That's referencing another Supreme Court decision, Seal of Law, from 2020, just 5 years ago. That exception, however, these exceptional conditions that might prevent a president from firing somebody, does not encompass the Institute of Peace, which is part of the executive branch and exercises considerable executive power through its foreign affairs, a domain exclusively within the Article 2 executive power, programmatic and grant-making activities. Moreover, under longstanding precedent, permanent equitable relief reinstating principal executive officers is unavailable. So even if they were to decide that the firings were somehow improper, those people don't get their job back. You cannot compel the Article 2 executive branch president to delegate his authority against his will. Like in any wrongful termination case, what you get is not the job back, you get monetary damages. Furthermore, the White House continues, the balance of hardships and the public interest favor a stay of this order from Howell putting the fired Institute of Peace people back into office. As the Supreme Court has recognized, the government faces greater risk of harm from an order allowing a removed officer to continue exercising the executive power than a wrongfully removed officer faces from being unable to perform her statutory duty. Here, this Court of Appeals argument is quoting from the Supreme Court 6-3 decision issued the day before this was filed, the 6-3 decision that reversed the same Judge Howell who's led to this appeal. The violence being done in our constitutional order to infringing the Article 2 executive branch president elected by the whole of the people in exercising his executive power is infinitely greater than a wrongful termination, even if it's determined to be wrongful. The district court, Judge Howell, reasoned that plaintiffs were irreparably harmed by damage to the Institute of Peace leadership, independence, reputation, and ability to carry out its statutory functions, but public officials have no individual right to the powers of their offices. They were not elected, these people. So you don't have a right to your job back. And by the way, the Institute of Peace can continue to carry out its statutory functions. Trump didn't eliminate the Institute of Peace. He simply replaced the leadership with people of his own choosing. Now the Institute of Peace can continue operating. It just will operate using executive authority rightfully delegated by the president. Plaintiffs here, the fired Institute of Peace people, have identified no irreparable harm in their individual capacities from the loss of employment. The public interest is best served by permitting the president to determine who ought to be entrusted with executive power. Otherwise, who makes the determination? These unelected, black-robed, tyrannical, inferior federal district trial court judges? Are they the bosses of us all? They have authority to delegate executive power? Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.